Hi, welcome back. There was a brief, close that door please. There was a brief break. I was down with malaria, but I'm not dead, which is lucky for you because you will get to pass some more exams before I die. Alright, today we have an urgent request from a Pappu that's appearing for an LL.M, Masters in Law paper. Exam is just 4 days away and the subject is judicial process, and Pappu has just bought the books. Okay, I have to keep this video under 15 minutes because there's some technological nonsense which happens after 15 minutes. This doesn't get loaded on YouTube, so let me cut to the chase right away. Today we're going to discuss the law of precedent. I'll tell you why. See, this is a Mumbai University question paper for Masters LL.M course, semester 3. Alright, this is how it looks. Okay. You have 1, 2, 3, 4, 5, 6 and 7 questions. All questions carry equal marks, 25 marks. You have to attempt any 4. That's how the exams are conducted for Masters these days. Anyway, so I have to help Pappu here. I am helping with the question pattern, question number 6 and 7, which is write short notes on A and B, A and B. So, master's degree students of LL.M, we are going to do Doctrine of Precedent, not President, not the Prime Minister President, not that executive president. Precedent, P-R-E-C-E-D-E-N-T, Precedent. Now, those of you who have done contract or who have done any of the other law subjects that you're supposed to do would have heard a phrase called condition precedent. This is the precedent from there. Okay, precedent, precede, succeed. This is that precede. Okay, precede means जो कुछ होने के पहले. Okay, succeed is after, precede is before. You have studied this in 6th standard English, if you remember. Precede, succeed. Doctrine of precedent. Now, let's come back to the philosophy of this program, which is to help you Pappus pass. How do you pass? You pass by using common sense to a great extent. Okay. You have never heard about doctrine of precedent and you are confronted with that question. What do? You take this finger and put it here. You take the other finger and put it here. Okay. Doctrine of... For God's sake, don't connect doctrine with doctor. Okay. There's no connection there at all. Okay. There's absolutely no connection between a doctor and doctrine. Doctrine here means philosophy. Doctrine of precedent. What could it be? Precedent. Cases already decided. पहले इस मुद्दे में, इस विषय में, इस संबंध में क्या फैसला किया गया था? By the apex court. Now what is the apex court? If you don't know that, yeah, Supreme Court is called the apex court. Why it is called, please check one of my other videos. I've explained that there. It's actually very depressing and demoralizing doing these classes, because I know one of you does not know what is the apex court. Which is the apex court in India? Okay, so it's depressing to teach you. Anyway, let me not get depressed. Doctrine of precedent. What was the decision taken by the apex court in a similar case earlier? Those of you who are doing LL.B will come across a subject called jurisprudence. In jurisprudence, there is a question called sources of law. In sources of law, this is visible on the board. Okay, you will also come across this stare. Stare. What do you do when you see somebody attractive? Stare. Diseases. Stare. What is the meaning of stare? Diseases in Latin. To stand by what is decided. Stare decisis means to stand by what is decided. Stare, the doctrine of precedent is derived from the Latin maxim, the Latin principle stare decisis. And today In order to take this class, I have a summary of papers written by judicial officers on this particular subject. I was searching for this particular notes and I came across an entire paper, 17 pages, written by the following honorable judges. The Honorable Justice U.M. Padward, who was the group leader of this paper, District Judge in Gadchiroli. The Honorable Justices M.D. Pathan, Justice V.M. Karadkar, Justice Bomedwar, Justice D.J. Patil. They have written a paper on law of precedent. I was researching for this video and I came across this paper. It is a surprise why you have not come across this paper. It is a surprise why you have not done any research. But that's another subject altogether. Let me rush. A precedent is a statement of law found in the decision of a superior court, which decision has to be followed by that court and all the inferior courts. As simple as that. So what is a precedent? A precedent is a decision by the Supreme Court in a particular matter, and that now decision is binding upon all the courts, including the Supreme Court itself. What are the aspects of precedent? Point number 1, you will get instant mark. I have reached the 5-minute mark. I have to rush through. I have to help you pass. So remember, Article 141 of the Constitution of India 1950. Let me give it a quick check. Somebody please research on this. It's your job to research on this, not mine. If I'm not mistaken, Article 141 of the Constitution of India talks about the doctrine of precedent, which is mandatory in India. The doctrine of precedent is expressly incorporated in India by Article 141 of the Constitution of India, which provides that decisions of Supreme Court are binding on all courts within the territory of India. So, first point to begin is that doctrine of precedent is derived from the Latin principle stare decisis, which means to stand by something that's already decided. And then you write the next point under Article 141 in the Constitution of India. It's mandatory to be followed. Okay. The main object of doctrine of precedent is that the law of the land should be clear, certain, and consistent, so that the courts follow it without any hesitation. Case law in Union of India versus Raghubir Singh, and here is a citation. I hope you can see it. AIR 1989. That is the case law for doctrine of precedent. I am going to quickly read it. The doctrine of binding precedent has the merit of promoting a certainty and consistency in judicial decisions and enables an organic development of the law. A law has to be certain. It has to be clear. So if there are 4 or 5 similar cases going on, one court will give one particular decision, another court will give another decision, there will be chaos. Therefore, doctrine of precedent's aim is to establish consistency, establish certainty of legal decisions. I am not going to go back to stare decisis. Do your research. You are a master's degree student. Just type this. Law of precedent. Okay. Summary of papers by judicial officers on the subject. You'll get 17 papers of one of the finest research done on the subject. Okay, in the case of Commissioner of Income Tax versus Messrs. Sun Engineering Works Private Limited, AIR 1993, second case law. The Honorable Apex Court held that while applying the decision to a later case, the court must carefully try to ascertain the true principle laid down by the decision of Supreme Court and not pick out words or sentences from judgment divorced from the context of the question. Just write these 2 case laws. Alright. Now, what are the elements of, just come down in your question. You have written so far, okay, you have written about Article 141, you have cited 2 case laws. Now write what are the elements of the doctrine of precedent. The first element is ratio decidendi. I am not going to get up and write all this. That's how it looks. Ratio decidendi in Latin means the reason for the decision. Ratio decidendi means the reason or the principle upon which the case has been decided by higher courts. What were the real reasons for which the court decided that in that particular way? In the case Krishna Kumar versus Union of India and others, 1990, Supreme Court, it has been observed that, in other words, the enunciation of the reason or principle upon which a question before a court has been decided is alone binding as a precedent. So, ratio decidendi, which means the reason for that decision, which is usually given in a speaking order, is an element of the doctrine of precedent. There is something called obiter dicta, element number 2. Obiter dicta means all that is said by the court by the way or the statement of law which go beyond the obiter dicta. Obiter dicta in Latin, in loose simple translation, is opinion, oral opinion. Obiter dicta, opinion while giving dictation. So while an order is being typed out, judge expresses a couple of opinion, which is not a part of the order, but which he expresses orally. That's obiter dicta. However, obiter dictum of the lordships of the Honorable Supreme Court is entitled to highest respect and is binding on all courts of the country. See, ratio decidendi has to be followed. Obiter dicta is not so sacrosanct, but is generally followed in India. It is observed in the case Mohandas, Isar Das and others versus A.N. Sadanandan and others, AIR 1995. Take a quick look. Write down quickly. I don't have too much time. High courts must accept as binding the obiter dicta of the Supreme Court in the same spirit as high courts accept the obiter dicta of the Privy Council. Obiter dicta of Supreme Court is binding on high courts. I did not know this. I thought it is not binding. It looks like it is binding. What is the case law? Mohandas, Isar Das and others versus V.N. Sadanandan. Alright, there is the third element called sub silentio. SUBSILENTIO. A decision is sub silentio if an important issue was ignored or was not argued by the counsel. Sub silentio, the subject was silent, an important mudda, an important point was not discussed in that particular case, in that particular decision. Okay. Such decision is not an authority on the point which is not fully argued as sub silentio. These are elements of the doctrine of precedent. Alright, now when precedent cease to apply, there are three main criteria to oversight the previous precedents as follows: overruling, reversing, distinguishing. We are not going to get into this. Now, there is an interesting question. Article 141 says decisions of Supreme Court are binding on all the high courts. But what about the decisions of high courts? Here it is. There is no specific provision directly empowering the high court to declare the law and making its decisions binding on subordinate courts. A high court's decision does not become a precedent. But however, it's just common sense that if Bombay High Court passes a decision, that becomes a precedent for all lower courts subjugated under Bombay High Court. It is usually also given due weightage by other high courts. Okay, but remember the difference between Supreme Court and High Court under Article 141 is that under Article 141, Supreme Court judgments form precedent. High Court judgments need not form precedent but are usually respected, and that's why they form precedent. Alright, I'm going to close up now. How do you score marks in this? You score marks in this by telling the examiner that you understand the phrase Doctrine of Precedent. Okay, the examiner is looking out for, do you understand? Okay, please don't write Abdul Kalam, APJ Abdul Kalam. Okay, don't write Mahatma Gandhi, don't write Pandit Jawaharlal Nehru. They are talking about PRECEDENT. Connected to stare decisis, Article 141. Connected to ratio decidendi, sub silentio, obiter dicta. You will sail through. Thank you. See you for the next short note. Bye bye.